Hello, this is Jakub from Warsaw.
Ще одна ремарочка. Якщо можна, для того, щоб був кращий звук, я попрошу всіх виключити Wi-Fi, якщо це можливо, тому що набагато буде краще трансляція.
Okay, that's good. So should we start? Okay. So the first slide is on, yes? Ladies and gentlemen, very good afternoon from Warsaw, Poland. My name is Jakub Sиелевиесиук. I'm a Polish and European patent attorney. And my difficult task this afternoon is to tell you about patents in the European Union. Next slide, please. I will try to do that. I will tell briefly about national patents, then about the institution of European patent as in its current shape. And by the end of that presentation about European patents, some disadvantages will be clear, and a need for a unitary patent will emerge. So to start with, next slide please. To start with national patents. National patents are the tool which you are perhaps familiar with. So in each of the European Union member states, there are patent offices, and if you want to get a patent in Poland, for example, you appoint a Polish patent attorney, and you file documents with the Polish patent office. Well, the documents should be translated into Polish, and then under national procedure, you get a national patent which is valid in Poland. The same in France, the same in Germany. So this national system is very much alike the Ukrainian system. And at the end, once you get a national patent, once there is an infringement, you go to national court, for example to the Polish court, and the Polish court decides on infringement in Poland. Next slide, please. Of course, this national system is not efficient enough when we are speaking about common market, which we have in the European Union, because in order to get protection in 28 European Union countries, you have to file 28 applications, and that is time-consuming, troublesome, and expensive. So it would be nice to have some common procedure by which you could get a patent in all European Union. Then next slide, please. And for that, the European Patent Convention was invented. So already a long time ago, in 1973, soon after the European Community was established, some countries signed a convention on the ground of European patents. That was signed in Munich. And next slide. At the beginning, there were only 5 countries in, I think, these were Benelux, Germany, and France. But as of today, the system of European patents covers actually all European countries, so not only European Union, but far more countries, 38 countries altogether, as you can see on the map. These are actually all the countries to the west and south from Ukraine. The legal basis for European patent is called European Patent Convention, EPC, and EPC provides one central procedure for filing applications, from filing to grant, and a few post-grant procedures like opposition and limitation. So to get your European patent, next please. To get your European patent, you file your application with the European Patent Office. The European Patent Office has its headquarters in Munich, has also an important branch office in The Hague in the Netherlands, and some other offices in Germany, Austria, and Belgium. Next slide, please. So you file your European application in the European Patent Office. You can file in any language. It can be Ukrainian, can be Russian, Polish, Latin, but after filing, the application has to be translated into English, French, or German, because the EPO only operates in these 3 official languages. Next. As a company from outside European patent system, for example from Ukraine, you must be represented in the proceedings before the European Patent Office by so-called European Patent Attorney. And you may select your European Patent Attorney from any of the 38 European EPC member states. Next, please. The practical advice for you would be that the representatives from the new European Union countries like Poland, Czech Republic, Romania, or Baltic states are relatively cheaper for hourly rates or for filing. And on the other hand, our Western colleagues from the old European Union, like Germany, France, UK, Netherlands, have much more experience. Can you still hear me?
Yes.
Okay, okay. The next slide, please. There is some. Okay. Under the centralized grant procedure provided by PPC is relatively fast, so you get your patents in 2 or 3 years of filing in most cases. Of course, there are exceptions. It is relatively cheap, so actually you will have to bear a cost of around 10 to 15,000 euro distributed over 2 years. And this is cheap comparing to 15 or 20 or 28 individual procedures in each country separately. And it is very important to know that the EPO is considered a very high quality authority. In particular, they do prior art searches, which are of very high quality. So if you get a European patent, it is usually a very strong, difficult prior art. Next, please. After the European patent is granted, it is published in the language of proceedings, which will be English, French, or German. And then you have to validate it in countries selected from these 38 contracting states in order to get a valid patent in individual countries. Next. In the validation procedure, the European patent is actually converted into a bundle of national patents in the countries you have selected. And these patents are subject to national law. So you will end up with a Polish patent in Poland, and a German patent in Germany, French patent in France, and so on and so on. In particular, if there is an infringement, you will go to a French court in France or a German court in Germany to decide on your infringement in that one country. Next, please. In most EPC contracting states, in order to validate your patent, you have to appoint a local representative, a patent attorney, and in most cases you have to file a translation of the whole patent or of the claims at least into the official language of that country, and of course you have to pay fees. Next. And this way we conclude that the European patent in its present shape has disadvantages. Namely, after it is granted, you have to pay a lot for validations, and you end up with a bundle of national patents, there is no one court competent to decide on infringement for the whole European Union. And it is our desire to construct such a court. Next. Of course, people realize also that validation means cost, and in order to make this cost lower, a so-called London Agreement was proposed. So under a London Agreement, some countries decided to waive the requirements of translation when validating European patents. In particular, the very good news for you is that at present, once your European patent is granted, it is automatically valid in the countries mentioned on the slide. So France, Germany, Ireland, Luxembourg, Monaco, Switzerland, and UK, which are main economies of the European Union. And you don't have to do anything, you don't have to pay, you don't have to hire a local attorney. Your European patent is just valid there, ex lege. And there is also quite a big group of countries, listed in the middle of the slide. So Albania, Croatia, and so on, up to Slovenia, in which you only have to translate the claims into the local language. So the claims are usually 1, 2, or 3 pages, not 30 pages, which saves cost. But nevertheless, still in many countries, including Poland, Italy, Spain, Greece, for example, the full translation into local language is required. Next. So, in view of the common market in the European Union, we would like to introduce a unitary patent. Unitary meaning no validations, no translations after grant, so that is cheaper. And there should be one court competent to decide on infringement. And the judgments of this court should be respected in all European Union countries. So that is our vision, which is not yet fully implemented this way. I will briefly present it, if I still have time. Okay, next slide. The idea of unitary patent, hopefully soon to come in the European Union, is the following. You will still file your patent application with the European Patent Office. The European Patent Office will grant the patent, and then you will have 1 month after the patent is granted to request so-called unitary effect, so to request your patent is unitary patent in the European Union. At present, so for the time being, they decided that such a patent should be translated into English, unless it was already granted in English. But in the future, we predict that machine translations will be of sufficient quality and that no translations will be required. So the European Union stipulates it should be 12 years, and in 12 years we should have perfect machine translations. And the European Patent Office is working on them together with Google. So it's on the way. It's still not very good, but they are doing something. And, next slide, please. And moreover, a unitary patent court has been established. So this court will be competent to decide in disputes resulting from European patents having unitary effect, and judgments of this court will be binding for all countries which are in the system. Next slide, please. And at present, there are 25 out of 28 European Union countries who are in the system, and actually in these countries the ratifications of the unitary patent court regulations are pending. However, some countries did not join the unitary patent club, namely Spain, Italy, and Poland are at present outside the unitary patent system. The position of the Polish government is that we are going to stay out of the system for some time, look at it, see how it works, and we have a chance to join in the future. if we decide that it's useful for our country. So in Poland, there will the so-called old or current validation system will continue in force. So next slide, please. So that's actually all I wanted to present to you, and thank you very much for your attention. And I'm open to questions.